Mr. Speaker. Honestly, what's with all the man screaming today? Especially when we're hearing it from members of the House who in 2004 were responsible for putting in place the 2004 foreshore and seabed legislation that created in the first place the discrimination, the inherent injustice and the confiscation that this legislation is supposed to but dismally fails to protect. And I note that other male members of the House who are part of this whole man-screaming thing were also opposed to the 2004 legislation and had quite a different view in those early years than they do now. But nonetheless, we have this bill before us. It is a disgrace. The preamble is very interesting for how it sets out the history of the process by which this bill has come about. And I want to address briefly just a couple of issues. I guess the issue that's raised for me in the preamble is the question of discrimination. It talks in the preamble that there was concern raised about the 2004 Act over the discrimination of the 2004 Act against whānau, iwi and hapu against Māori, and that was highlighted by the United Nations Committee on the Elimination of Racial Discrimination and the United Nations Special Rapporteur, and that's quite right. The committee and the rapporteur, when he came and visited here in his subsequent report, did highlight the discrimination, particularly around the unequal treatment of Māori and the unequal treatment of the different kinds of title. Now, this is an issue the Greens have raised before, and we will be dealing with it later on in the committee stages as well, but the different treatment to the different kinds of title, freehold title on one hand and customary title on the other. And that was a large part of the discriminatory criticism of the United Nations Committee. It was also an issue that was raised by the Ministerial Review Panel that was set up by the Māori Party to have another go at looking at this. Because don't forget, we've had 3 major rounds of public submissions on this legislation, only to find ourselves dealing with exactly the same bill that we dealt with in 2004, that still confiscates Māori land and treats Māori in a discriminatory way. The Ministerial Review Panel were clear too that the principle of equal treatment had to be a core part of any further framework on how to deal with the foreshore and seabed issues, and that there should be, they said, equal and consistent treatment for similar cases for Māori and property rights. But what we know from this legislation that there are 2 areas of discrimination that I'll briefly mention now. The first, of course, is that the proposal to put in place public access only applies to those areas where there is or could be customary title. It doesn't apply to the more than 12,000 private freehold titles in the foreshore and seabed. That itself is an explicit act of discrimination, racial discrimination, against Māori and against the Māori forms of title and management of land. And the member asks whether it should be the case. If there is to be a principle of public access to foreshore and seabed, then yes, it should apply equally, regardless of the titles. If there is to be some other consideration around the treatment of public access, then let's consider that. But if the principle is... Sorry? Well, that raises the question, doesn't it? It raises the question of what do you do then with the kinds of titles that councils might have or ports might have or other forms of industry. And it might be that you can set up or have a process that considers things like the safety of the public in those areas, the particular use of those areas. But if you don't have the basic principle that public access to the foreshore and seabed should apply equally everywhere, and then look more carefully at only those areas where it shouldn't for particular reasons, what you have is discrimination in law, racial discrimination in law. And that is what this bill is doing. It is putting that racial discrimination into law because it doesn't consider issues around safety. It doesn't look at the kinds of ownership of the 12,500 freehold titles that there are in the foreshore and seabed. It is very blunt and very broad. It only applies to whether there are freehold titles. Mr. Speaker.
Territory.
Thank you, Mr. Speaker. Freehold titles are protected from the principle of public access and doesn't have to be provided, but customary title held by Māori is treated as a secondary form, as a lesser form of title, and therefore should be subject to public access considerations. That is discrimination. There is another area of discrimination that was raised in the Select Committee that is referred to obliquely in the preamble, and that's around when government can remove the rights of a person over their land. Now, under normal circumstances, if you have freehold title and the government wants to take that land for some form of infrastructure that they consider important, the process is worked through the Public Works Act, and there is a process for looking at the value of that land, and it's a fairly straightforward, clear process. It's a fairly clear process for those who have freehold title. But if iwi or hapu or whānau were to have customary title in a piece of land, and the government decided that they needed that land for a road or to build a water pipeline through, the Public Works Act does not apply. In fact, they have to negotiate that with the Crown, and the Crown gets to decide on their own, effectively, whether or not there is any compensation to be paid at all for the acquisition of that land and therefore the interruption of the rights of that whānau or hapu or iwi over that land. So again, what we have here is the treatment of customary title as a secondary, lesser form of title that doesn't have the same rights as private title, isn't treated and valued the same by the Crown or by other agencies. Because if the Crown wants your customary title land, they can go and get it, and they don't have to give you compensation. It's entirely up to the Crown to decide whether or not they'll do it. It is not the case if you have freehold title. It is another form of racial discrimination in this legislation for no reason, for no justification at all. There is no reason why we cannot have the same principles for the use of land for important government infrastructure to apply to freehold titles and to customary title as well. Now, these are details beyond the principle, and the Parliament is well aware of the Green Party's opposition to this legislation on principle. But if you look also through the details, it just gets worse and worse. And it is these details of discrimination that show how much of a failure the Māori Party National Party negotiations have been over trying to resolve the inherent injustices that were put in place by New Zealand First and the Labour Party in 2004. Those inherent injustices remain. The principles of the failed principles are still in place in this legislation, and the failed details are still in place in this legislation, just as they were in 2004. So it is a great disappointment. The preamble sets out the history. The history is a lot dirtier, in my view, than those 4 paragraphs make clear. The preamble is very broad in the way that it discusses the issues, tries to give the 2004 legislation a worse record than this one, which of course is not true, because they are effectively exactly the same and effectively do exactly the same. They're simply negotiated with different parties. It is a real disappointment to know that Māori MPs in particular in this House, from across the House, particularly with the Māori Party and with the National Party, will be supporting legislation which has at least 2, and there will be more, clear examples of anti-Māori racial discrimination against Māori, against customary title and against tikanga Māori into law in just a few days.
Chair.